Supreme Court of Nigeria this last Friday declared Executive Order 10 on the funding of state judiciary and legislature as unlawful and unconstitutional. In a 6-1 split decision, majority of the court's 7-member panel agreed that President Muhammadu Buhari had exceeded his constitutional powers in issuing the executive order on May the 20th, 2020. The Apex Court also dismissed the 66 billion naira suit filed by the state governors against the federal government. The 36 state governors had in the suit sought an order of the court to compel the federal government to take up funding of capital projects for state high courts, Sharia Court of Appeal, and Customary Court of Appeal. The governors informed the Apex Court that the 3 courts were the courts of the Federation, and as such, the funding of their capital project should flow from the Consolidated Revenue Fund of the Federation. The matter of Executive Order 10 proved the controversial one at the time of its issuing, and could indeed prove to be more so now that the highest court in the land has delivered judgment on it. Well, joining us now to share his thoughts on the development is Abiodun Owonikoko, a senior advocate of Nigeria, a lawyer and principal partner at Synergy Attorneys. You're welcome to the program, Mr. Owonikoko, SAN. Good morning.
Good morning.
Good morning.
Happy weekend.
We wish you the same on this wet Saturday morning. Good morning. So good to have you join us. So let's start this way, SAN. How will you dissect this for us? Yes, the Apex Court has given its ruling, and it looks like the federal government and President Muhammadu Buhari, of course, lost on the one hand, and then there's another loss if you look at the fact that the court also rejected the 66 billion that the state governors were asking for. Who has won? What has won? Is this about the Constitution taking its pride of place, or are we seeing politics, in and out around all these issues? Explain to us what really has happened and how it will impact on the Federation.
Thank you for having me this morning. It's not anybody's loss. It's the Constitution that has won. You recall that at the height of this controversy in May 2020, I granted an interview on your platform here, and I expressed the very respectful opinion that the executive order could not fly in the face of a challenge against its compatibility with the constitutional prescription. So it's not that surprising that the judgment of the Supreme Court has gone the way it has gone. However, the judgment is coming as a form of anti-climax, and that's where the federal government itself should be commended for gingering the various state governments to activate genuinely and with bona fide the provision of Section 121(3) of the Constitution as altered by Alteration Number 4 of 2017, which expressly, what had been previously implied, stated that the consolidated revenue of the state must be the source from which both the legislative and the judicial arms of government get their direct funding without being superintended by the executive arm. The reason I say it's anticlimactic is that since that executive order, which was like a hunter smoking into a rat hole to smoke out the rat, Mr. President used the bullish pulpit of the presidency to force the various state government to operationalize Section 121(3). Whether it was believed that the procedure adopted would fly against constitutional challenge is a different thing. But I think ultimately the executive arm of federal government has achieved its objective, the judiciary has been vindicated, and the governors themselves, by reacting to the implications of that executive order, have across board through the Nigerian Governors Forum come to an agreement with both the JUSAN, the judiciary, and the federal government to implement the provision by enacting state fund management law for the purpose of independence of the legislature and the judiciary. At the last count, I know close to 20 of the various state governments have enacted this law, which more or less uh, adopted with varying degrees the provision of Executive Order 20, order number 10 of 2020. So, in a way, I believe that the entire country is the winner, and nobody should feel any kind of sense of defeat in the outcome of what the Supreme Court has done.
I mean, this is largely a legal issue. You've got a problem and you think it's unconstitutional. You've gone to court and the Supreme Court, 6 out of 7 members have agreed with what the attorneys general of these 36 states had to say. So, I mean, for that case, I guess there is a winner and a loser when you look at it through that context. However, it is, though albeit a legal issue, it does have, social ramifications. If there's been so much talk about restructuring for the better of Nigeria, wouldn't this have been a perfect example of that? And there's also been criticisms of the state governors in the sense that you don't really see them unite when it comes to issues as to how they can tackle poverty. But when it comes to money, all of a sudden, you've got state governors running to court. So when you look at the fact that this sets restructuring back a few steps, don't you think, or can I ask, with the nullification of Executive Order 10, ultimately state governors now get to decide how much money the legislators get and the judiciary gets? I mean, in your legal opinion, have the courts not, the judiciary in this matter, have they not ruled against their own independence? Is this not a negative thing for them?
Oh, not at all. On the contrary, whereas before the Executive Order 2020, it has been a matter of executive discretion by the various state governments how much, and in what manner monies due to the other two arms of government are released. Whereas the Constitution, as at that time, expressly, by the amendment we made in 2017, took that discretion out of the hand of the governors. But because most of the state legislatures are in the pocket of the governors, they were unable to assert themselves, and the Constitution itself is not a self-executing instrument. So there needed to be some form of framework by which you can judge compliance with Section 121.3. Now, the governors, by assenting to the various fund management bills that were now initiated by consent of all of them at the level of the governors forum, can no longer exercise those powers. There are bodies set up which will start with budget preparation, budget allocation, and then appropriation. Once the appropriation is done in form of financial bills in the State House of Assembly, the governor has no say anymore. Whatever is due from consolidated revenue to each of other arm of the government goes directly through the Office of Accountant General of the State to their account management bodies. In the court system, the head of court and the chief registrar manage the finances of the court. At the level of the State House of Assembly, they have State House of Assembly Management Commission, and then the Speaker or whoever. And then, so as it is today, what we have done is to create a defined framework for operationalizing Section 121.3 by way of state legislation. If you recall, when this adjustment became a bit of a problem in year 2021, and the judiciary staff went on strike in trying to enforce and pressure compliance with financial autonomy, a state like Lagos came out, and the CJA of Lagos State, High Court of Lagos State, confirmed that before even the executive order, Lagos State, unlike most other states, had actually on its own initiative been implementing financial autonomy by releasing capital votes due to Lagos judiciary to them in substantial sums, in substantial percentage, but not totally. So some states, out of their own sense of responsibility, had been trying, albeit in an informal way, to comply. But now, there is already an agreement between the Nigerian National Judicial Council, the federal government, the Ministry of Labour, the Nigerian Bar Association, and the various state governments that they would enact laws that would ensure compliance with financial autonomy of both the National State House of Assembly and the judiciary in terms of the capital project, which actually is the main thing, and then salaries and what have you. So I believe that what has happened today actually deepens the federal nature of our constitution by defining the limit to which federal government can go in superintending how state government exercise their own powers, and also limiting the powers of one arm of state government dominating and lording over the two other arms of government. So it's a welcome development. The state governors, as a matter of principle, won their argument, but as a matter of practical reality, lost the battle because they wanted to retain control of the funding of the legislature and the judiciary. But in the course of this fight, they've lost it. It was never theirs in the first place.
All right, I said. I mean that's actually well said. And I noticed that two lawyers, senior advocates of Nigeria, were invited by the Supreme Court to give their advice in the course of looking through the matter. Is that the standard normally for the Supreme Court, so that you invite lawyers, to give their opinion and then Supreme Court takes from it? That's one part of my question. The second part will be, how do you think that this will further galvanize the governors to always come together to challenge any executive orders or any directives from the federal government that may appear to be against the constitution or against the principles of the federation? We know that Lagos and Rivers states have always tested the law, but now that this has happened on Friday, how do you think that things might proceed in terms of the relationship between the governors on the one hand and the federal government on matters that may be mutually exclusive?
Thanks. For the first question, the dispute about the executive order number 10 was a constitutional issue. In normal circumstances, these actually are the kind of cases that should go to Supreme Court, not cases about motor accidents, cases about land matters, which is why the court is overwhelmed with so many private civil claims that bog them down. So it is very welcome that this case went to Supreme Court. And once we have a constitutional issue that is novel, the Supreme Court is normally comprised of a full panel of 7, not the normal panel of 5. Now, the fact that Supreme Court agreed to constitute 7 panel members, especially whenever it's a state and federal government litigation, where their original jurisdiction is invoked, a full panel normally sits on it. When that happens, if it wasn't a case involving federal government, in fact, any case that touches on validity of a federal legislation or the constitution, the Supreme Court is, as a practice by their rules, will normally invite the Attorney General of the Federation as a friend of the court, which is what we call the amicus curiae. Beyond that, you also now want to have the perspective of a broader view on how to approach the matter, because the constitution is a living document. It's not meant just to resolve singular dispute alone, but to be used to guide the future. So you want to have this disinterested, dispassionate opinions from other advocates. And that's what Supreme Court did. It's not the first time. They've always done that in very critical cases that involve hearing so many perspectives. And you can see that at the end of the day, they had the benefit of the likes of Agbakoba SAN, Chivawomolo SAN on the other side. Some of the argument prevailed, not necessarily in favor of one party, but in accordance with what they think the Constitution prescribes. They have the argument of the likes of Mahmoud Bagadi SAN on the other side, especially on the issue of the capital project and funding. I think the state government, they threw in the claim for recovery of their expenditure on capital projects and for future funding of that by federal government as a sweetener. They realized that they had a very strong case on the constitutionality challenge to the executive order. But they wanted to drive home their point by saying, look, you cannot have the benefit and not take responsibility. If you want, assuming the Supreme Court were to hold that federal government will micromanage how state legislature and judiciary were to manage, then they would then have to take the burden of funding some of those capital projects. That was the thinking of the state government. And I think that point resonated with the Supreme Court. Although you have a dissenting opinion on some of the issues, but it makes the court to see the full ambit of the issues involved, and so that their eventual judgment has come to clarify a lot of things. I think that's it. Then on the other point about the governors coming together, well, it's not often that all the governors, even when they have a matter at the Supreme Court, will be on the same side. But on this particular occasion, because it's a straightforward dichotomy between the powers of the federal and the state government, it was easy for all of them to come to a consensus about taking a stand. So they filed the action by all together, and they all took the same position. In some cases, especially if you have emotive and divisive issues, like maybe resource control, it's very unlikely that you will have had a situation whereby all the state governors, attorney general, will take the same stand like we have in this case, where what is involved actually is really constitutional. It's not, there are no interests, as it were, beyond constitutional determination. So I think whenever such matters of this nature come up, it's good for our system and rule of law that we take a stand that will make the issue clear for resolution, rather than throw in so many diversionary points that would probably misguide a resolution and create more confusion. In this instance, the judgment of the Supreme Court has come out clearly to streamline the issues and resolve most of the points having to do with financial autonomy of the various state legislatures and judiciary vis-a-vis the powers of the state governor to.
All righty. I mean, budget. Thank you very much, Essay. And I mean, still on this topic, I do want to ask you whether or not you think, and not to ask you to preempt the federal government, but do you think we can expect a move from the federal government to amend the constitution along these lines, since the Supreme Court did in fact rule against it, saying that it's the order, for example, was unconstitutional? Can we expect that at some point there will be moves to amend the constitution along these lines?
Well, no, for two reasons, I don't expect that. First is that there is the duty of respect by each branch of government for the prerogative of the when it comes to interpreting the constitution. That is the exclusive preserve of the judiciary. That's number one reason why I don't expect the federal government to seek to amend the constitution to now aggrandize or appropriate the powers which the court has held. In a constitutional federation, certain powers are divided and spread between the tiers of government, and it will amount to jurisprudential inconsistency, and also it will tweak our constitutionalism if federal government were to want to move in that unitary direction. Number one. Number two. Number three is that even if they were to adopt the procedure of amending the constitution, don't forget, for constitutional amendment, you need 2/3 of the various states Houses of Assembly to ratify whatever is done at the level of the National Assembly. So even if that were to be attempted, I don't see the chance, given there is a unanimity of all the various states for this stand to be taken in terms of financial autonomy at the state level. So I don't see that as a possibility. But there is always opportunity or room for working grand compromises about certain on implementation. There could be some grand compromises about maybe setting standards about what is the minimum of your budget at every financial year to be allocated to maybe the judiciary. What is the threshold of amount to be allocated to the state House of Assembly, for instance? So that, because all these arguments about even National Assembly allocating so much to themselves is a function of budgetary priorities. If a state says, I will not commit more than 5% of our state budget to funding state House of Assembly, and we will not commit less than 15% or 20% of our state budget to judiciary, that could be something that all the states would probably sign on to by way of a moral commitment. I can see that happening.
All right, Mr. Owonikoko, just a quick one before we wrap it up. What lessons do you think that the local government administration should draw from this judgment? We know that the governors are always quick to challenge the federal government in certain areas. But then hardly do we see local government chairmen whose rights, in most cases are being trampled upon by the governors. Ever do we hear of them going to court to challenge governors? So what lessons do you think they can draw from this? Maybe to give them some courage, galvanize them into action so that when things happen, they too can draw reference from what the Supreme Court has given to the governors in this instance?
Well, as a matter of principle, the same reasoning that guided the Supreme Court in resolving this issue applies to financial autonomy of local government. But don't forget, in the case of local government, the constitution itself creates a joint local government, state and joint local government account system. So local governments are not, by the constitutional provision, protected absolutely from state involvement in how their finances are managed. And don't forget, it's not a case of local government having 3 branches in the proper sense of the word. They are just to be democratically elected under a law enacted by the state to ensure that they are democratically governed. It, however, does not mean that when allocation meant from the federal government for local government are released, a state government can hijack and then apply it as it does, as it wishes. The problem with local government is lack of political will, and often because of the manner in which local government elections are held, where almost every government in the state ends up controlling all the local government as a matter, as every state organized local government election. So you are not likely to see a political division of opinion between local government leadership and state governors when they more or less behave like the apron strings. But if that our democracy matures and we begin to have more diverse representation at local government level, where maybe a state government may have less than half of local government in the state that are controlled by its own political party, then those groups can galvanize themselves to challenge state excesses. And we have seen it sometimes when their common interest is attacked. Let's say a government, we have seen several, there have been judgments in the last 4 or 5 years, where Supreme Court has held that local governments are not appendages of state government. So when a governor is elected and decides to dissolve and create caretaker, Supreme Court has said that you cannot do that. And in those cases, they always galvanize themselves together, unanimously challenge decision of the state that violates their rights. The only problem is that, unlike state and federal government disputes, local government disputes have to emanate from state high court and travel all the way over time to Supreme Court. Unlike this one, where the Supreme Court decision, its original decision can be invoked and the matter decided at just one tier of, which is the final point. You go initiate the action in Supreme Court, and Supreme Court decide, and it's final, and they don't know that too. I think that's part of the little challenges that local government face. But with determination and political will, and a sense of trying to deepen our democracy, it does not always have to be that until a matter is investigated, people must know the limits of their authority. Governors must learn to behave responsibly, even with all the powers at their disposal, because the power is held in trust for the people ultimately.
All right. Thank you so very much, Mr. Jelili Abiodun Owonikoko, Senior Advocate of Nigeria, for your time and the perspective that you've shared with us on this important topic. Thank you so very much.
Thank you so very much.